The first thing after a significant disaster is to make sure that injured personnel and their families are taken care of well and immediately. That, of course, can have its own consequences down the road if litigation should follow. The next thing that's important in a disaster is preservation of evidence. You should make sure, of course, that all evidence is collected, that nothing is destroyed. Pictures often are necessary. We've got to be careful about how pictures are taken. The advice of counsel is quite important in all of these endeavors after a significant event. Cooperation with authorities, investigative authorities, government authorities that may be involved in the accident or its aftermath. You want to prevent, wherever possible, the leakage of inappropriate information, inaccurate information, conclusory statements that are made by company personnel before investigation is complete. All of those kinds of things can be damaging in the litigation that may ensue. So control over those kinds of things is quite important. Of course, another significant thing that needs to be done in the wake of any accident or disaster is collection of the facts. Taking statements from witnesses, particularly employees, is quite important to make sure what they know. And of great importance is taking statements from what we call negative statements from witnesses or employees to find out what they don't know. You want to ensure that they don't suddenly remember something later on in the litigation that they actually did not know immediately after the accident. Mediations are very good from the settlement point of view in that it represents an opportunity for the injured plaintiff, for the first time sometimes, to hear from someone other than their own attorney how good their case is, how bad their case is, what the position of the opposing parties are. So from that point of view, it's very effective from the point of view of getting the case settled. But the amount of the settlement and how the settlement itself is handled is a completely different thing, which they may be completely unprepared for. This is where the services of a structured settlement consultant can be very, very useful. First of all, the plaintiff may be unaware that such a thing is available. He may not understand that a structured settlement can be available to take care of, for example, future medical expenses, or simply to replace the income stream or the support that was received from a person who has died in an accident. So the mediation is a great opportunity for this information to be transferred to a plaintiff and his attorney so that he can be aware of these possibilities. In some respects, a structured settlement may not actually save the defendant a dollar amount, but it may make a great savings in that it may be the very vehicle that makes the settlement possible when the plaintiff learns of its availability and what it can provide for future years. In the case of the plaintiff's attorney, many these days are structuring their own fees. So the mediation setting is a great time for the structured settlement consultant to advise not only the plaintiff but his attorney of the benefits of structured settlements for both of them. May be of great advantage to the plaintiff, may also be of great advantage to the plaintiff's attorney. And of course, the portion that is allocated to the plaintiff himself will be tax-free. So in the end, the payout that's available from a structured settlement may well exceed the negotiated amount of the settlement, and with its tax-free benefits, this is frequently a selling point for the structured settlement and enables the entire settlement to go through, whereas it may not have been able to go through under other circumstances. In the mediation process and in the consideration of a structured settlement, there's an opportunity for the plaintiff's attorney to consider the special needs of his client. The special needs may include, for example, for the survivor of a decedent, the replacement of the income stream that was expected in the way of support for the person who has been killed in the accident. The plaintiff in a particular case, particularly in a death case, may not be capable of earning an income. In those circumstances, a structured settlement is particularly appropriate, and the plaintiff's attorney should really consider the needs of his client in this situation in replacing that income stream. Structured settlements can be of great benefit, even in smaller cases, depending, of course, on the circumstances. There may be individuals, such as a minor, whose needs are primarily in education, or in persons who have future medical expenses that must be paid for. Structured settlements in cases that do not have a high dollar value, but where the future needs of a particular plaintiff need to be addressed. Structured settlements can be extremely valuable in these situations, even though large sums of money may not be involved. Once again, the services of a good structured settlement consultant are invaluable in this situation, and particularly useful in the mediation environment, where the benefits of the structured settlement can be explained directly to the injured person, or in the case of a minor, to his or her guardian or tutor. These are the considerations that a good plaintiff's attorney, with the assistance of a good mediator and a good structured settlement consultant, can put together a settlement which is beneficial to all the parties involved.